Welcome to Virtual Face-to-Face. I'm Alex Lukowski, AVP of Communications. The acclaimed father of the Constitution, James Madison, is often quoted saying that all men having power ought to be distrusted. Although he probably did not use those exact words, he was careful to load the Constitution with lots of checks and balances. The trouble is, the contours of constitutional law are only uncovered when it's tested. And it is being tested right now, particularly the limits of presidential power. The enumerated powers granted in Article 2 seem straightforward: run the government, serve as commander-in-chief, make treaties and appoint officers, and of course, take care that the laws be faithfully executed. It would be impractical for the Constitution to get into the nitty-gritty of exactly how a president should do those things, so it doesn't. As a result, for the last 235 years, challenges in the courts have tested those boundaries. Article 1, of course, gives Congress the authority to collect money and provide a plan to spend it. But what if a president doesn't want to spend the money they're given? Well, President Nixon sought to withhold money from programs he didn't like, so Congress passed the Impoundment Control Act in 1974. That act was tested again last month when the Trump administration paused all federal financial assistance. The courts have since temporarily restrained that pause and ordered funding to be released, but the issue is not settled. Now, one tool used by every president, except one who didn't live long enough to do it, is the executive order. They aren't laws, but directives to agents of the government to do things the president is empowered to do under Article 2. The most impactful of those was certainly the Proclamation 95 issued by President Lincoln in 1863. It's also called the Emancipation Proclamation, and it changed the legal status of 3.5 million African Americans held in slavery in Confederate states. FDR issued almost 4,000 executive orders. During the Great Depression, he forced Americans to sell their gold to the government, established the Works Progress Administration, among other things. 5 of his orders were overturned by the courts, although sadly not the one that confined 120,000 Japanese Americans to concentration camps during World War II. Today, just in 5 weeks, the second Trump administration has issued a flurry of executive orders imposing tariffs, pausing foreign aid, exiting the WHO, Paris Agreement, restricting immigration, establishing the Department of Government Efficiency, and renaming Mount McKinley and the Gulf of America, and much more. Of particular significance to higher ed is a threat to withhold federal funding to institutions that employ what that order calls illegal DEI and DEIA policies, although it's not clear exactly which policies or practices are illegal. A federal judge here in Baltimore temporarily blocked that one on Friday. And the actions of executive agencies can likewise be very impactful. On February 7th, NIH announced it would limit payments for indirect costs in research grants to just 15%, potentially saving the government and costing universities some $4 billion. Again, on Friday, a different federal judge extended the block on that 15% limit pending a future ruling. Many of those agency actions are also being challenged by way of the Administrative Procedure Act. Since the 1940s, the APA has controlled how new federal regulations can be established. If new rules aren't made the right way and properly published in the Federal Register, they may have no effect. And many more orders and regulations are being challenged by lawsuits. Some of them have also been temporarily restrained, but the question remains, what are the limits of presidential power? And is there any way to tell what's going to happen next? Joining UMB President Dr. Bruce Jarrell today are 3 great legal minds from our own University of Maryland Francis King Carey School of Law to help us understand a little bit more about what's happening. Dean and Professor Renée Hutchins Laurent, University System of Maryland Regents Professor Mark Graber, and the Michael Millemann Professor of Consumer Law, Jeff Sovern. Now, later in the program, you will have a chance to ask your question. Please write any questions in the Q&A area. They're going to get lost in chat, believe me. So please use the Q&A. You can make it anonymous, but I hope you won't. We'd like to hear your voice, so listen for your name and open your mic when the time is right. Now, please welcome UMB President Dr. Bruce Jarrell.
Good morning to everyone. It's a pleasure to be here. Memories of the years of COVID and these face-to-face meetings that we had every month. Of course, there's been a lot going on in our state and our country over the last 2 months. Some of you may know there's lots of concern in the state government about funding, particularly for the universities. So we're watching that closely. And then there's a lot going on at the federal government. And in fact, seeing all that was going on, we just thought it was time to have a face-to-face discussion again. I suspect this is one of several because there are many topics that I want to know more about, and I think you will too. So we'll start with this one, but understand that we'll move into other areas. And so I would ask, as we do our questions, to keep them fairly narrow to the executive order limits of the presidential powers. But we're going to get to some of these other things relative to NIH funding and many other topics. So I'd like to go ahead and begin because we're going to talk for about 20 minutes and then open the mic up for questions from the audience. So I'd like to welcome Professor Sovern here, first time we've worked together, and start with a question of, man, I'm seeing a lot of executive orders. I don't know always how to interpret them. Could you give us a little bit of guidance on what are they, on whose authority are they, and how much weight do they carry practically and legally?
Sure. Executive orders are a mechanism for the president to tell the people who work in the executive branch what he wants them to do. He sends them out, and then they're supposed to read them and follow them. But they can't do everything that the executive order calls for, or maybe a better way to put it is there are limits on what an executive order can call for in our system. For example, if an executive order contradicts the Constitution, the agencies are not permitted to do that. The executive order has to be consistent with the statutes Congress has passed. One of those statutes, as was alluded to, is the Administrative Procedure Act, which provides additional limits on on what agencies can do. So, for example, the APA says agencies can't engage in conduct which is arbitrary and capricious. That's kind of a vague phrase, but courts have explained what it means. They say, for example, that something is arbitrary and capricious if it uses factors that Congress didn't authorize the agency to use in making a particular decision. If an agency issues a rule that entirely fails to consider an important aspect of the problem, that too would be arbitrary and capricious. So while agencies are supposed to follow what the president says, their ability to do so is constrained by limits from the Constitution and statutes.
So the executive order is speaking to the agency, and the agency is executing that order internally, but also where it has contractors and people like us who rely on those agencies. So there's both the internal and the external effect of an executive order.
Exactly.
And so is there one that sticks in your mind that's particularly notable over the last 2 months that you see as effective or not effective, or not to put a political interpretation, but rather a, can we implement these things?
Well, for an example of something that is being subjected to attack on arbitrary and capricious grounds is this order to reduce the amount of funding that the NIH provides in indirect funding to institutions with grants. So the various states have sued, Maryland is among them, to challenge that. And one of their arguments is that the decision to pick a number 15% as opposed to what had been negotiated is arbitrary and capricious. Where does that come from? Why 15%? Why not 10%? Why not 20%? Another argument that's made is that order applies not only to future grants, but also to grants that have already been awarded. And the complaint claims that the order failed to take into account the fact that it was going to be applied to grants that were issued in the past, and that too is arbitrary and capricious. I sort of think of it as like going to a restaurant, ordering food from the menu, The server brings the food out and you say, well, this looks good, but I'll pay for the ingredients, the cost of the ingredients. I'll pay for the chef's time. But to the extent that the menu price includes a markup for your rent, for your electricity, I'm not paying for that. And so then what does the restaurant do in that case? It's already made the food. It's brought it to the table. It can't really give it to anybody else. And the states like Maryland are arguing that that's arbitrary and capricious.
And would Professor Graber or Laurent want to add anything to this particular part of the discussion?
No, I think Professor Sovern has nailed it.
Ditto, ditto.
Ditto, ditto. Okay, well then let's move on. This term of impoundment keeps coming up. It was a new term to me. I had to learn what it meant in the law circles. So who would like to talk about that? Renee, is that your topic?
Sure, happy to chat about that. So good morning, everybody. Thank you, Dr. Jarrell, for having me. Thank you, Alex, for introducing us. I am always happy to appear with the absolutely brilliant faculty from Maryland Carey Law. So Professor Graber and Professor Sovern, audience, you are in for a treat. They know their stuff, so to speak. So impoundment, when we think about impoundment, right, most of us think about having our cars seized by mean tow truck people, right? That's not what it means. So with regard to impoundment, if everybody can think back to like high school, junior high civics, we've got a series of checks and balances in our government. And in the three branches of government, of the three, Congress is the branch that is supposed to have tax and spend power. So Congress is the branch that tells us, here's how much you've got and here's how much you can spend on that particular thing. Problems come up when presidents don't like the things that Congress has said money should be spent on, or don't like the amounts of money that Congress has directed to be spent on a particular thing. And so then you get into the question of when there's that headbutting, what do you do? So as Alex mentioned at the top, in '74, Nixon didn't like some of Congress's spending priorities. And President Nixon decided he wasn't going to spend money on the things that Congress said money should be spent on. So the Impoundment Control Act was passed to limit a president's ability to do that. And so a president can say, I'm not going to spend money on these particular priorities or in these particular ways. There's just some process that has to happen with it. And so if there is rescission and there is deferral. So rescission you can think of as a president saying, fine priority, but I don't want to spend that much on it. Deferral you can think of as a president saying, I don't want to spend money on that right now. And there are different processes that go with that. So if you're doing the rescission option, the president has to file a notice. He's got to explain why the money shouldn't be spent in the way that Congress wants it to be spent. And then you get 45 days. You sort of get a 45-day lag where the money can actually be held. That's just the process that has to be followed. On the deferral side, that applies within the fiscal year, and the president can only defer the spending, but can't punt it indefinitely. The problem here, or the complaint here, is that the new administration didn't follow the process that was supposed to be followed. And it's not entirely new. So in the last Trump presidency, Trump didn't like dollars that had been allocated to be spent on Ukraine, more than, I think, $200 million that Congress had allocated to be spent on Ukraine. And he didn't transfer the money, didn't spend the money the way Congress had directed the money to be spent. And there was later a finding that, in fact, the ICA had been violated. And yet here we are again.
Right. And so that, of course, raises a question for Professor Graber. So what if the president just flags his nose at everybody and says, I don't care what you said, I'm going to do what I want? What happens?
Well, we don't know. What potentially happens is Abraham Lincoln, in his 4th of July address in 1861, said, some of you think I may have done some things that are unconstitutional. I don't think so, but you may ratify my actions. And it turned out Congress pretty much ratified and said, even if your actions, you shouldn't have done it without our permission, we're now giving you permission to do these things. What I think is being highlighted in both Professor Sovern and Dean Laurent, we're talking about an aggrandizement of presidential power, but we should also be talking about the enfeeblement of Congress, in the sense that it's not the case that Trump is fighting Congress and winning. Congress isn't doing anything, and our Constitution presumes that most of the items in the executive order, should we get rid of DEI, that's a decision supposed to be made by a legislature, not by one person. When a legislature says we want to spend $10 on coffee and $10 on iced tea, the president isn't supposed to be able to say, well, I'm only going to spend on coffee. When the president refuses to obey a court order, it's Congress, typically for the sanction. And Congress is not asserting its prerogatives, even if it simply meant it's a Republican Congress. Good. Everything Trump is doing embody in a statute.
Mhm.
But we have a problem. If Congress refuses to act, we wind up with one branch of government.
One of the things I love about these sessions is I learn new words, and that was a new one on me, Mark. Enfeeblement. I'm sure it's common in your world. I think in the medical world it means something very different, but probably still the same idea. Great word. Thank you for that. So in this case, then, the answer is there is no check with an enfeebled Congress.
The check is Congress, for the
Yes.
most
Right.
part. The check is the next election.
Right. There are midterms coming up.
The midterms coming up. Wow. One of the terms that I keep reading about, and I know you all have expertise on, is this concept of unitary executive. Could one of you make a comment on that concept and why it's important for us to know that's part of the debate?
Probably, I guess
Defer to
that's me.
Jeff and Mark. Yep.
Yeah. The idea of the unitary executive is when Article 2 says the president has the executive power, proponents of the unitary executive say anything that's an executive power, the president has, even if it's not specified in the Constitution. So if it's part of the executive power to completely control executive branch officials, then the president has that power, that everything that goes on in the executive branch is the responsibility of the president. Now, it's worth noting that while people say this is the American way, almost every state, for example, elects members of the executive branch separately, does not permit the governor to unilaterally hire and fire people. And indeed, for most of American history in the 19th century, it was understood Congress could determine a great many of the duties of executive branch officials. So it's a doctrine based on where the president has the executive power, but most historians think it's a misreading of 18th century language, and most states think it's a misreading of constitutional language.
One way the unitary executive plays out is with independent agencies. We have a Federal Reserve that gets to raise interest rates or lower interest rates regardless of what the president wants the Federal Reserve to do. The president, as the statutes are written, does not have the power to fire the people who make those decisions for the Federal Reserve. But if you take the unitary executive to the extreme that some folks want to, the president could fire anybody in the executive branch, which includes the Federal Reserve, which includes the other independent agencies. The president gets to basically make their decisions. If we go to that extreme, We could have presidents, for example, lowering interest rates right before the election to provide an economic boom, even though after the election that might lead to significant inflation. The Trump administration has taken the position that it does have considerable control over the independent agencies. It hasn't taken the position that it has that much control over the Federal Reserve, though it has asserted some power over the Federal Reserve more than previous presidents have. So, and the Trump administration has already started the process of seeking the testing of whether these independent agencies are constitutional, whether they can be independent of the president, and we're going to see how that plays out when the courts
And
weigh
of course, the Inspector General, I think, falls into that category too, does it not?
Yeah, the inspectors general, in some cases it's less clear, but there are statutes that permit presidents to fire inspectors general if they follow a specific process, which President Trump has not followed when firing the inspectors general whom he attempted to fire and may have succeeded in firing.
Well, I know we've got actually a record crowd online today. I'm seeing 474, and that's just on the Zoom call. So I think you're setting a record, and for the three of you, you're obviously rock stars, at least in 474 people's minds. That's a good thing. But what I'd like to do, Alex, because I know that you're teeming with questions, is let's get some questions from the audience.
All right, well, I thought we would get to this question later, but we have so many people asking some version of it. I want to bring in Howard Haft to give voice. Howard, are you there?
Yes, I am. Thank you, and I particularly enjoyed learning the new term enfeeblement. Also, I think I'll add that to my lexicon for sure because I'm feeling that way. Yeah, the question is, I think, in everyone's mind. So, to what extent does the nation or others respond if the president is defiant, even against courts, including not excluding the Supreme Court?
Well, we have to look not to the United States because we've never had a threat of defiance on this scale. But we can look to other countries. Just recently, a South Korean head of state tried declaring martial law for his own purposes, and the legislature responded by impeachment. We see similar things happen in Taiwan. In Taiwan, the Constitutional Court played a role in getting rid of a president who sought to aggrandize power. Similar things can happen with courts in South America. So there are methods of getting rid of a president who acts in ways that are unpopular. The real question is Republicans control all branches, and they are violating Madison's Federalist 51, which, unlike every other, is a bit of political science, not a law. Federalist 51 says that people will identify with their institution. So a president will not be able to seize congressional powers because nobody in Congress will want to cede power to the president any more than, say, the dean would like to say, well, I'll cede power to somebody else. No, I like it because when I act, it's for the public good. Now what we see, and there's a very famous article in my field on it, that it's parties. People act consistently with their parties, and when a party controls the presidency, members of Congress and even some justices are inclined primarily to do what they think is in the party interest, empower the president, even if that means, to use that wonderful word again, enfeebling their own institution.
So what go ahead, Jeff.
I also wonder to what extent we might see things take place outside the government if the president starts to ignore court orders. I think one of the reasons businesses find the United States an attractive place to invest is because our government is seen as very stable. If our government suddenly seems less stable, I think businesses will pause investment. They may move investments to other countries. That would lead to things like falling stock markets. The value of the dollar might fall. Interest rates could conceivably rise. And I think that would put pressure on people in the government to act that they might not otherwise feel. So I think there'd be economic consequences, and of course, those eventually affect individual people as well.
And so the only thing that I would add, so yes and yes. And what I would add is that now is not a time for a sense of hopelessness. Now is not a time to feel disempowered. Donald Trump is president because we elected him president. And the makeup of Congress is what it is because we elected Congress to be what it is. This is still a democracy, and we will get all of the democracy that we deserve and are willing to fight for. And so if you have not read Project 2025, I would strongly suggest that you do. It is available. It is publicly available. It is free. It's 900 pages. You can put yourself to bed with it every night. It is literally the playbook. If you are wondering where this is going, it's not a secret. It hasn't been a secret for years. And so inform yourself. Read Project 2025. Pay attention to what is happening in your local communities. If you don't like what is happening in your local schools, show up at the school board meetings. Be active, be engaged. That's what a representative democracy looks like. I think that we have had the luxury for quite some time in this country because things, for the most part, stayed within the guardrails of just trusting that democracy would work without our active, informed, engaged participation. That is not true. And so now is the time for us to re-engage. We are seeing, to Professor Sovern's point, right, we are seeing pushback outside of the political space against some of the decisions that are being made. So some companies have sort of preemptively acquiesced with regard to some of the executive orders. They are now being sued by their shareholders because compliance, preemptive compliance with those executive orders is costing them on the balance side. And shareholders are asking them to take account for that. So we have a lot of power. We can give it up, or we can use our power in strategic and thoughtful ways to hold on to the country that we want. We can continue to push America to rise to its highest ideals, or we can throw up our hands in despair and retreat. And if we do that, we lose. No question about it.
Okay, Alex, how about another one? Thank you.
One of the things I love about this university is we have a lot of smart people. So I'm going to bring in Joshua Hitch, and you're going to think, question, or you may think, as I did, he must be a law student or law professor. I don't think he is, though. Joshua, are you there?
Hi, yes, I am. Can you hear me?
Yes.
Hi. Yes, so my question is, since Congress and the Supreme Court both appear to be compliant in flouting the executive powers, what can the states do to resist the illegal overreach of powers? How can we use state rights, which ironically is kind of the classic right-wing argument? How can we use that to protect the states from the aforementioned overreach? Can it be used at all even?
States have brought lawsuits in federal court to challenge actions by the executive. And there are sometimes questions about whether states have standing to do that. But for the most part, the courts seem receptive to the idea that they do. And so to the extent that they have standing, states do have this power and have asserted that power. Many states, including Maryland, have brought cases to challenge executive actions taken by the Trump administration. And those cases are still at very preliminary stages, but so far in many of them, courts have entered temporary restraining orders or preliminary injunctions, basically preserving the status quo, so that the courts have time to figure out who should win the case. And that will be a much longer process.
A point of constitutional law, and then a point more generally. Ever since 1842, when the Supreme Court said state officials do not have to implement, and the federal government cannot make state officials implement the Fugitive Slave Act, the rule has been that the federal government cannot commandeer state officials. We see Trump's attempt to commandeer the mayor of New York, but assuming our state officials don't commit federal crimes, they cannot be commandeered or bullied into enforcing any Trump provisions. A second thing, a state like Maryland can do, is not constitutional, but remind people, here's what we do. If you're pro-life, well, let's look at infant mortality in Maryland and in Mississippi. Let's look at what it is to live, the education we offer people in Maryland compared to the education we offer people in Mississippi. Because Trump's vote comes from people who feel their life chances have been diminished. And one of the things we can do in Maryland is say, the life chances of our citizens living in states with our policies are not being diminished. They're being increased. That maybe it's the Trump policies that we're seeing in the executive orders that are causing babies to die bluntly and are diminishing the life chances of many of Trump's supporters.
I just go back to the state question. We have another anonymous question, or we have several related questions, who asks about the other direction. What happens when Doge or the Musk team violate Maryland citizens' privacy rights, for instance? Are they able to, is the state able to take some legal action on behalf of Maryland citizens?
The Attorney General certainly could. I do think, though, on this point, and I want to make a really, really narrow point here. Putting aside what you think of Elon Musk, putting aside what you may think of his qualifications for the job that he has been assigned, it is not unheard of for a president to appoint a presumptive expert to take care of a job. And so I think that to the extent that we are attacking things that are coming out of the Trump administration that people are opposed to, we should be careful to attack things surgically. It's a scalpel, it's not a sledgehammer. And that we should be very specific with regard to what our concerns are, and should not be painting with too broad a brush.
There are a number of defenses a state has to federal action, though it's important to understand that if a federal action is legal, a state can't interfere. But with respect to Musk, it's rather interesting. A federal judge asked a government attorney yesterday in a lawsuit, who's the head of this organization? And the attorney said, I don't know, which is a rather bizarre answer, because while Dean Laurent is absolutely correct, a president may appoint someone, a president can only appoint to an office Congress has created in the way Congress has defined the office. The president doesn't get to appoint the head of basketball for all of the United States unless Congress creates the office.
Right.
If Musk is operating illegally, if he was not appointed to an existing office, if he was not appointed in the appropriate way, if his office is not exercising legitimate powers, then he's a criminal. And as a criminal, he is subject to Maryland state laws, and there is no preemption if he is acting legally. Though it's important to understand this is why Congress really matters. If Congress had sanctioned all of this, Maryland would be largely stuck because congressional laws by rules of preemption and supremacy clause trump contrary state policies.
2 points. First, Maryland has joined with a group of other states to challenge or in an attempt to protect the privacy of Maryland citizens and other U.S. citizens, to challenge the provision of information to DOJ by the Treasury Department. I'm not sure where that case stands at the moment, though. There was at one point a temporary restraining order issued, but I haven't monitored it closely enough to know if it was lifted. As for the second point, Congress, I don't think it's likely that Congress will grant Trump the broad powers he seeks because of the filibuster rule. As long as we have the filibuster rule, the Republicans do not have enough people in the Senate to get substantive laws passed. Now, the reconciliation procedures don't require the 60-vote threshold that the filibuster requires, but those procedures are largely limited to budgetary matters, and so I don't think that can be used unless the parliamentarian changes her view. I don't think those rules could be used to accommodate President Trump as to substantive law either. Of course, if the Senate does away with the filibuster, then all bets are off.
An anonymous questioner asks, would you speak on how the end of Chevron affects the power balance with the executive branch? Does it simply move power from executive agencies back to the legislature, or can it be diverted back to the president himself? If the power goes back to the legislative branch, may the legislative branch delegate it back to the president if they happen to be from the same party, which they are right now? And could this have something to do with the higher number of executive orders? There's a lot in that question there.
Let me take some of it. The Loper-Bright case, which overturned Chevron, provided basically that it's the courts that interpret statutes, not the executive. So to that extent, it diminished the power of the executive. However, it also said that if Congress passes a statute delegating power to the executive, then the job of the courts is to respect that as long as the delegation of power is permitted under the Constitution and the agency acts consistently with that power. So if Congress has passed a statute letting the executive do something, the executive still gets to do that. There are some administrative law scholars who take the position that statutes, for the most part, do permit that kind of broad delegation or already provide for it, and that therefore Loper-Bright won't actually change very much despite all the attention it got. And there are other administrative law scholars who say, well, yes, the case says that, but that's hard to reconcile with the general tone of the Loper-Bright case. So I guess we still have some uncertainty there. What I would say is Loper-Bright increases the power of the courts. It diminishes the power of the executive unless Congress chooses to give it more power by its own terms. And I think what will happen is the Supreme Court will return to Loper-Bright and give us greater guidance about how it wants this to play out. Does that answer the question?
I have no way of knowing, but it sounded pretty good to me. So let's bring in Mike Ravenscroft, who has a question. Mike, go ahead.
Sure, yeah, I had a couple, but and I appreciate the panel. This is extremely interesting and enlightening. A question about, given the fact that the strategy as stated by some of the folks on their team around, muzzle velocity, right? How can we flood the zone with as many illegal acts as possible before we get caught? What should the strategy be of the states and of, ordinary citizens like me who are calling our congresspeople every day, as far as prioritizing? Are we doing this based on economic pain? Is it what will trend? I'm just kind of curious how you fight a strategy that is predicated on doing as much damage as possible in a short amount of time as possible.
Kind of a political question, but do you want to, where's the legal nexus in that? Does anyone want to address that?
Well, as in, we can't fight hundreds and hundreds of court battles at once, or can we? Maybe we can.
Yeah, it is a political question.
Yeah.
And Dean Laurent, I think, gave the answer. If you're opposed, all you can do is your own flood the zone strategy. If they're going to flood the zone with official orders, you have to get as many people as imaginable to protest as much as imaginable. Now, you can't do everything because most of us have lives. But, you can increase the time you go. So instead of going bowling one night, you go to the school board meeting. You call your congressman more often. You give a little more to the causes you're there. That part of, I think, a finding of comparative constitutional law is you can't beat a political movement with a legal decision. If the political movement gains strength, it will either ignore the legal decision or eventually replace the judges who made the legal decision with judges who overrule it. The only way you can beat a political movement, and MAGA is a political movement, is with a stronger political movement.
And the only thing that I would add to that is I would really, really, really encourage everybody on this call to be honest with themselves about how informed and politically engaged they actually are. Like, how many of you can name who your sheriff is? How many of you can name who your county exec is, your school board president? How many of you can name 5 of the 10 members of your county council? Can you name who your state's attorney is? Do you know who your local public defender is for your district? Can you name who the judges on the Maryland Supreme Court are? Can you name who your local circuit court judges are? In a representative democracy, we do not have the luxury of complacence. When we are complacent, democracy will slide to those who are paying attention. And so it literally, if there is one thing that everybody on this call did to make a difference, I would say inform yourself and then vote in the midterms. There are midterms in November. Be prepared to vote every single candidate on the ballot, every single one, right? Don't just vote the top of the ticket. Know something about every single one of those offices. We wrote off Secretary of State offices for so long like they didn't matter, and clerk of court offices like they didn't matter. And right, where do you think the redistricting is happening? It's happening in state legislatures, right? And so vote, inform yourself, and vote.
A lot of questions have to do with things you can't know the answer to, or what's going to happen in the future. But since so many have to do with research, well, maybe, but research grants, that impacts the lives of so many people here at this university. I want to read this one. As I understand your responses regarding the 15% cap on indirects, is it more likely that the outcome from the courts will be that this new cap is not applicable to pre-agreed awards? You talked about that, Mark, a little bit. Is there strong enough precedent for the courts to uphold that existing grant awards cannot be altered? What do you think?
I think the way courts are going to answer that is not so much by looking at the merits, what the number should be, but asking whether the agencies follow the proper procedures in saying it's 15%. Again, it goes back to that question of, is this an arbitrary and capricious action, which is largely a procedural standard? Did they consider the right aspects? Is the explanation that they come up with, does it actually conflict with the evidence? Is it implausible? Did they use factors that Congress didn't authorize? If they find that the number was selected on a basis that satisfies those criteria, then the court's job is to say, okay, they followed the right procedures, it's now 15%. If they find that it did not follow those criteria, then the court's job is to send the matter back to the agency and say, you didn't follow the right criteria, and if you want to make it 15%, you have to do that. And then it's up to the agency either to come up with a different number or to come up with criteria that show that 15% is not an arbitrary and capricious number. And whether the agencies can do that, I just don't know.
Just for the record, right this minute, we are on existing grants getting the negotiated indirect rate. I don't know how long that'll continue for. There's the indirect rate concern. There's also the review and awarding of new NIH grants, which is a major it's a stoppage in terms of the flow of research ideas and dollars. So it's not limited to the IDC rate. It's limited to it includes other things as well. So, Alex?
Yeah, well, one of the other big topics, obviously, that people are concerned about here on campus is the impact on our diversity, equity, inclusion efforts. I want to bring in JP Pierre, who is one of our DEI officers at the School of Medicine. JP, are you there? Just have to open your mic.
Use Dr. Quezada, who had a question.
Oh,
Thank
okay.
you.
Well, go ahead.
Oh,
Hi, Alex, and thank you all. I would like to say, to add to your number of 400 plus, we're listening in a room with 15 people here in the room paying attention. So
Wow.
thank
Okay.
you for this. My question, and Alex, I agree, I was really thinking about the DEI executive order, but really with all of them, we've seen, some glimmers of hope with some temporary restraining orders and injunctions, and sort of deadline extensions, so kind of buying some time. But I guess the question is, how much time does that buy before ultimately a decision is going to be made on whether or not these executive orders are constitutional? Just kind of trying to get a sense of timeline.
This is going to be a really unsatisfying answer, and I'm going to apologize up front for it. It depends. It depends upon the judge, right? So what the judge is doing in imposing sort of the temporary pause, the judge is attempting to hold the status quo to allow the parties time to argue and the judge the time to assess and decide. And so it just depends. It's hard to say. It's really hard to say.
Another piece of that is we can expect that whoever loses at the district court level will appeal to the Court of Appeals, and that whoever loses at that level will appeal to the Supreme Court. So the timeline could be rather lengthy. Sometimes the courts move very quickly, and on important matters like this, they'll feel pressure to do that, or greater pressure, but other times they move more slowly. And sometimes the Supreme Court says, well, we'd like to let this percolate a little bit more in the lower courts, other times not. So I hate to say this, but there's a tremendous amount of uncertainty about what's going on. And unfortunately, that question speaks to another area of uncertainty. If you'll forgive a metaphor, we have an administration that's pushing the envelope beyond where it's been pushed before. We know what the old envelope looked like. We can identify arguments for keeping the envelope in the same shape that it used to be. We can identify arguments for changing the shape of the envelope. And we can make predictions sometimes as to what courts will do. That doesn't mean our predictions will come true. But at the end of the day, we don't know what the courts are going to say the shape of that envelope should be when all the litigation is done. And by the time that comes, we could be years down the road.
A very crucial question is, what's the Supreme Court going to do with respect to the lower federal courts? Traditionally, lower federal courts would make decisions. The Supreme Court would wait. It'd be appealed to an intermediate court. They're called circuit courts. They decide whether they're going to keep the decision or reverse it or have an injunction. And the court would only get involved when somebody appealed to the Supreme Court. Now, when litigation starts, the Supreme Court, often it's something called the shadow docket, comes in and sometimes says, we're actually going to issue an injunction against the state practice that will be in effect while the case is being bubbled up. Or sometimes when a lower court issues an injunction, they say, no, there is no injunction. This is going to be very crucial because if, as Professor Sovern and Dean Laurent, and they're absolutely right, it's going to take time. Well, during this time, is there an injunction on the order, in which case, when the Supreme Court makes a decision, it'll be the status quo has operated for 2 years of some version? Or will the Supreme Court lift all injunctions such that schools will have to make major adjustments? And so a decision will wind up sustaining a set of policies that haven't been practiced for a year and a half.
One other thing that it affects many people we know is what's happening with federal employees. And I want to bring in Saifa Poole, who has a question about that and what they can do to protect themselves. Saifa, are you there?
I am here. Can you hear me okay?
Absolutely. Go ahead.
I want to thank all of you for this face-to-face. And I agree and understand that the courts primarily would have the power to override some of the executive decisions. But I'm speaking from a very common, everyday person view. And the courts take a lot of time, but everyday people that's losing their jobs, that's unable to feed their family, losing health care, that's an urgent, time-sensitive need to know now decision. So where will that come from, and what do you see? I mean, and they're confused. They don't know whether they have a job or don't, and who to listen to. So can somebody speak on that, and where do you see this going?
Steve, I wish I could tell you something reassuring. I have friends who worked at USAID. My brother works for the federal government. There is so much uncertainty and fear, and that is really hard to watch. I think if you're just watching sort of the news and you hear about, they're taking letters off the front of USAID, or they're cutting the budget to this agency, or they're instructing these agency employees they have to turn memos in. You can forget that what is sitting under those headlines are real people with families and bills and anxieties and stresses and pressures, and all of us know some of those folks, all of us. And I think that one of the lovely things about UMB and one of the lovely things about being on this campus is that, in my experience, we don't forget about the people who sit under those stories. And I know that it is incredibly important to the leadership of the schools. I'm speaking for my fellow deans here. And for President Jarrell and his administration, that the stories that you're talking about matter. They are the things that keep us up at night. They are the things that make us want to make sure that we are getting the answers as right as we possibly can. But unfortunately, this current climate doesn't allow us to give a lot of certainty in some spaces. We're given the best answers we can, but sometimes we can't say on Tuesday at 9 a.m. this thing is going to happen, or you should take exactly these steps and then you will be forever protected, because the same uncertainty that you are talking about is the same uncertainty that we are in and making decisions in. But I feel the pain you're talking about. It's hitting my family every day.
If I could make what I think is a friendly amendment to something Dean Laurent said early, and that is what you can do. It's not simply vote, it's mobilize. And the reason I want to say mobilize is if in the midterms, the question is, should faceless bureaucrats lose their jobs? Hey, I'm all for it too. I think we're all for people who meddle in our affairs should lose their jobs, right? Even the five of us, we're there for it. But what mobilization does, and it's challenging because the methods of mobilization aren't what they were when I was in grad school, aren't what they were 20 years ago, is it provides information. So it's very crucial. The people losing jobs, as Dean Laurent, are people. Here's who they are. They're not who they think you are. They're people just like you. By the way, remember the people who lost a job at FAA? Flight accidents are up. These are things that affect you. Mobilization is the means of getting word out. And part of what happens is we've lost that, is we're sort of a society that doesn't communicate to each other. And these things have to be communicated. The schools, to say, we have to communicate. What happens to cancer research at the University of Maryland, to Maryland residents, if this budget gets cut? What happens to babies? What can we do for babies? Because it's simply, should we cut the budget of this gigantic institution? Again, we're all for it. Should we double the infant mortality rate in Maryland? That's a different question.
We're about out of time. And I know we've still got 470 people on the call. What I would suggest is we get one of these scheduled pretty quickly to continue this conversation and to perhaps tread into some other areas that are on people's mind. Does that sound right to you and to our panelists? You're willing to come back, are you?
All right. That's great. Yeah, we do have lots of questions out there.
Even though there was no free food.
No free food.
That's part of budget
That's
cuts.
at noon today, Mark. Noon today.
All right. Well, then, thank you. We will try to get more programs set up. Obviously, our community is very interested in understanding what's happening and getting some ideas about what they can do. So we'll try to do that.
So I just want to thank our three panelists. I want to thank all of you in the audience for your participation. I'm sorry we don't have more time, but we'll get it scheduled pretty quickly and continue the conversation. So with that, thank you all very much. Alex, it's all yours.
All right. Thanks, everyone. Take care, and we'll hurry up and schedule more of these. Have a good day.
Thanks, everybody.